Nonetheless, though, it's an important subject, and it's an issue that seems to bedevil every single case that I do in the tribunal. Every case seems to have an issue with one side alleging that the other hasn't met their disclosure obligations, and if only they did, then their case would be illuminated to the extent that nothing further would be needed. There are issues about confidentiality, and there are issues about privilege. What I'd like to do is to start off by very briefly looking at the background context of disclosure, in particular, the tribunal's jurisdiction and the basic principles around disclosure. I'm going to do that relatively quickly because I'm aware that overwhelmingly these are principles with which you will be very familiar, but they're important context. I'd then like to go on to talk about specific disclosure applications and look at really practically when we should be making those applications and how we ought to be making those applications. I particularly want to talk about them because I have to say that in my experience, applications for specific disclosure are some of the most poorly pleaded and poorly presented applications that come before the tribunal. And so looking at how we do those better is a really useful exercise. And the third thing I'm going to talk about is elements of confidentiality and some recent cases that have dealt with that in a tribunal context. So very briefly, the basic principles underlying disclosure in the tribunal. The key jurisdictional principles are drawn from Rule 29, case management orders, and Rule 31, which is a rule that expressly deals with disclosure of documents and information. You will be familiar with both, but when you're dealing with disclosure, just read them again. Have them at the forefront of your mind. Remember that this is the basis upon which any order will be made. One thing to note, of course, is that Rule 31 has an express reference to geographically to Great Britain. Rule 29 does not. If there is an issue about disclosure from persons being overseas, then the case law on this, Snarnoff and YZ, is the relevant case here, particularly the Court of Appeal judgment, and I put the relevant reference up there. And essentially the takeaway point is that Rule 31 is limited to Great Britain and essentially involves disclosure against a non-party. But disclosure with respect to parties to the litigation should be addressed through Rule 29, which isn't territorially restricted. What are the tribunal's powers? Well, the starting point here are the powers of the county court, and there is express reference to CPR 31 that is used as the grounding for orders made by the tribunal. We'll be familiar with Rule 31 and in particular standard disclosure, which comes under Rule 31.6, and the need to disclose documents upon which you rely, documents which are adverse to your case or to another party's case, or that support another party's case. And Rule 31.4, which I've partly cited there, deals with what is involved in disclosure. It's not simply a physical document, it's anything in which information of any description is recorded. And one point to be aware of course, is that the tribunal's powers are not constrained by the reference to CPR 31. So it is open to the tribunal to make wider or different orders. But I have to say, I think that's a rather academic point because it's difficult to see the circumstances in which the tribunal might make an order for documents that don't come within the ambit of standard disclosure in any event. In terms of orders for disclosure by the tribunal, often cases, the most simple cases, will make orders for standard disclosure without any reference to the parties. Typically in straightforward unfair dismissal cases, there would be standard orders. In more complex cases, orders for disclosure will follow a preliminary hearing and critically will follow clarification of the list of issues. Applications for specific disclosure. The first thing to notice about applications for specific disclosure is what the essential test is. The test is the test of necessity. It is not a test of relevance. That is not enough. Now, clearly, it is a necessary condition for necessity that the document is relevant. But very often you will see in the tribunal applications being made on the basis that a document is relevant. That is not enough. The cases are very clear. The test is one of necessity. It follows from that that necessary for what? Necessary for the determination of the issues. So ensure that any application is focused on the issues the tribunal needs to decide. Link them to the list of issues. When we think about necessity as well, necessity also imports the concepts of the importance of the document, the time and the cost of recovering the document, the issue of proportionality. So necessity needs to be seen in the context of the overriding objective, and particularly when one is resisting an application, issues around proportionality and cost and reasonableness are relevant considerations for the tribunal to consider. Fishing expeditions are not permitted, and again, I've cited some cases that make that point very clear. When we think about a fishing expedition, of course, what do we mean? Essentially, it is disclosure which is aimed at identifying a cause of action or identifying a potential defence. If that is the objective of the application, it is simply a fishing expedition. So if we're crafting an application, how do we deal with that? Well, very simply, by focusing on what the issue is to which disclosure is necessary. If there is an identified issue for which disclosure is necessary, it cannot be a fishing expedition. Rather, it's focused on what the tribunal needs to decide. I mentioned earlier that many applications for specific disclosure, in my experience, are poorly made. Why are they poorly made, or how are they poorly made? First of all, they identify the wrong test. They identify the test of relevance rather than necessity. And secondly, they tend to be generalized. They tend to look for wide-ranging, generalized groups of information or documents, and they don't really tie the application to the particular point that the tribunal needs to decide. So what can we do to improve that? Because an application for specific disclosure, when well argued, can be a really powerful and effective weapon in the tribunal. The first point, I think, which is the second point on the slide, unfortunately, is the difference between documents and classes of documents. The first thing to do is to identify, well, what particular documents do you want? What are you after and why? Be as specific as you can. This is an application for specific disclosure. It is not a generalized request for lots of documents or access to the data room. Differentiate between a particular document and a class of documents. For example, one can imagine a situation where a claimant is seeking specific disclosure of a recording of a meeting. It's very easy to be specific about that. The claimant may say, I was at the meeting. It was recorded. It was agreed between the parties it would be recorded. And I want a copy of that recording because there's a critical dispute about what was said in the meeting. If you are seeking disclosure of a class of documents, try to narrow it down as much as you can. You may narrow it down in terms of time. You may narrow it down in terms of theme. For example, rather than saying any communications between the disciplining officer who dismissed me and the HR department, you might say, in the period between the letter inviting me to the disciplinary hearing and the disciplinary hearing itself, all communications between this particular person and that particular person. the more specific you can be, the greater weight your application will carry before the tribunal. Review the pleadings. It's always interesting how often there will be either express or implied references to documents in the pleadings that perhaps for some reason don't come out in standard disclosure. In those circumstances, we should be very aware that if we want those documents and they've been set out in your opponent's pleaded case, there's a very strong argument and a better argument for securing an order from the tribunal. Get very clear instructions from your client. It seems an obvious thing, but your clients will be aware of what documents ought to be available, ought not to be available. There's often disputes, for example, over notes taken at meetings. Well, your client, whichever side you're representing, will have been present at that meeting. Were notes being taken? If they were, who took them? Was it agreed that something would be done of them? So identify the documents in particular that you're looking to secure. The next thing is to consider, well, if and when to make an application. And here, it's important to bear in mind issues around proportionality, issues around cost, and the chances of success. You don't want to make an application if you think it's going to fail. You don't want a finding that actually a set of documents aren't necessary to determine an issue. Consider whether you want to make such an application at different stages. So you may wish to first ask for the documents. That may be determinative. If the other side writes back and says they never existed or we don't have them, that may be sufficient. It would certainly be sufficient for the tribunal to prevent any further order being made. It also may be sufficient for your purposes. If you know they don't exist, that may give you the opportunity in cross-examination to say they ought to have existed. You ought to have prepared them. And the fact that you didn't is something from which a negative inference ought to be drawn. Practical considerations, again, these are really important. First of all, make sure you go through the process we saw on the previous slide of identifying the relevant test, identifying the issue to which the documents relate, and tying that together with why it's appropriate for the tribunal to make an order in those circumstances. Make sure when you make an application that that correspondence is included. If you're resisting an application, that correspondence may be determinative of the issue. If you have already told the other side the documents don't exist, then frankly, if they pursue an application for specific disclosure, then you ought to be making a cost warning in those circumstances. An application must be supported by evidence. This again is something that is frequently forgotten. But if you say that a document exists or a document does not exist, provide the evidence for it. It may be in the form of a witness statement. It may be in the form of associated documents. For example, we referred to the notes of a meeting. Let's say we were seeking specific disclosure of those. If you received a letter after the meeting that said, "We will send you the notes in due course," that's compelling evidence that the notes existed. Include that evidence. Issues of confidentiality. Issues of confidentiality regularly come up in the tribunal, and there's a wealth of case law on it. First of all, what are the basic principles? Again, we'll be familiar with them. Confidentiality per se is not a ground for protecting documents from discovery. And Science Research Council is the classic case on this that is consistently referenced in the subsequent cases. The other case I've referenced on this slide is Plymouth City Council and White. It's an EAT case. It contains, paragraph 11 contains a really good statement of the principles relevant to specific disclosure and confidentiality. It's often cited, but again, if you're preparing or resisting an application where these issues are relevant, I really do recommend just refreshing your mind about those and reading through that guidance when you're preparing for the application. Again, the test of necessity. Is disclosure necessary for a fair trial? If it is, can they be disclosed without disclosing what actually is confidential? Is it the case that what is necessary to be disclosed actually doesn't cover what's confidential? So think about how redaction can be used. There could be an anonymized schedule. There could be anonymization of the individuals concerned. Comparators could be A, B, and C, for example. We've all seen that in the cases that we do. Alternatively, there could be a confidential bundle that is available only to the tribunal, but is not available for wider public dissemination. So there's a range of options available to the tribunal. Be creative, but really focus on what is the confidentiality that I'm seeking to protect, and do no more than that, because the tribunals won't give you a wider or more generalized order. A particular case dealing with confidentiality that many of you will no doubt be familiar with, but is really important in this area, is Frewer and Google. It's a case from last year in the EAT. Now, this was a case where the claimant had made a claim for unfair dismissal, but it was a Section 103A claim, a whistleblowing claim. So the allegation was that they had been dismissed because they'd made a protected disclosure. That was the reason, or the principal reason, for their dismissal. And the whistleblowing related to alleged anti-competitive behaviour by Google, and really it was about favouring certain clients. Google, the respondent, sought orders in the tribunal for the anonymisation of those client names and the redaction of a whole host of information, and the tribunal granted that order. But the respondent's application in the tribunal, although it referenced Rule 29 and Rule 50, it didn't clearly set out which rule was relied on and why that was relevant to the application that was being made. So again, there's a sense of a broad generalized application that doesn't specify what is the rule that's relied on, what is the particular document or information that I want to be protected, and why. How did the EAT deal with this? Well, first of all, the EAT set aside the orders made by the tribunal and remitted the issue of redaction back to the first instance. They identified a range of important principles, and paragraph 18 of Frewer is helpful in this regard. It's worth just going through if you're dealing with these sorts of applications. Commercial confidentiality may be a good reason to redact. And the first principle is confidentiality or sensitivity may be a good reason to redact irrelevant sections of an otherwise disclosable document. But the important point there is irrelevant sections, because essentially what the tribunal is saying there is if it's irrelevant, then there is a prejudice to its public disclosure that is not necessary for the determination of the issues, and in those circumstances it would be appropriate to redact or in some way not disclose those points. And again, that can be done under Rule 29, the tribunal's general case management powers. But where the material is necessary, it can still be restricted but it has to be restricted on a different jurisdictional basis. What is the basis for restriction in those circumstances? Well, there it would be Rule 50 that provides for derogations from the principle of open justice. Now, Rule 50 applications, as many of you will be very familiar with, they're very difficult to secure. There's a host of case law about it, but the starting point is the principle of open justice. So the starting point is that these things are done in the open with public access to the documents and the proceedings in court. And Dring and Cape Intermediate holdings that I've cited there, particularly from paragraph 34 onwards in the Supreme Court, is a really good summary of the principles. And particularly if you're resisting an application, but even if you're making one, but particularly if you're resisting an application, citing those principles and having them at the forefront of the tribunal's mind will be very helpful indeed. It's also important to remember that the public interest, the principle of open justice, includes the public interest in press reporting. And that includes reporting the persons and the institutions involved in the application. Rule 50 will also differentiate between what is commercially confidential and what is commercially sensitive. There's a host of information that our clients would rather not have in the public domain because it's commercially sensitive. But it's difficult to say that much of that is commercially confidential. So it's important to differentiate between those two groups of information. How do we proceed in applications for disclosure in that particular context? Well, what the EAT said was the application that has succeeded in the first instance didn't expressly identify the relevant rule upon which the order was sought. And there was a sense of a generalized request for restriction. That is not okay. It comes back to the principles that we started with a few minutes ago. Be clear and specific. State clearly which rule is being relied on. If the information is not relevant and you're looking for a general redaction of particular parts of the documents, Rule 29, General Case Management Orders, is the relevant section. Say so. If the information is relevant, but reaches the level of commercial confidentiality that it ought properly to be redacted, the relevant rule is Rule 50. Different principles will apply, and those principles must be before the tribunal and are highlighted in our submissions. Say so. Where there is a specific rule, that is the rule that we should be using. And applications relying on alternative rules should be express about the alternatives that they are seeking. And again, FURA at 39 to 41 is really helpful in identifying the approach to confidentiality and applications in this context. But all these things come back to the same basic principles. Be specific, be clear, highlight the particular jurisdiction that is relied upon, and if you're resisting the applications, go through those same steps from the other side. Is there ambiguity? Is it unclear what the jurisdictional basis is? If so, it's appropriate to resist applications of that sort. Thank you very much. I'm now going to hand over to Dan.
Thank you, Mark. Hello, everyone. I must be honest with you, the topic of disclosure in the Employment Tribunal isn't one that naturally stirs the soul. You can look in vain for poetry in the Employment Tribunal Rules of Procedure 2013. But what it lacks in emotion and romance, it perhaps makes up for in importance. I'm going to make two relatively brief points building on Mark's excellent introduction. The first and the longer of my 2 points is simply this: consider the implications of guessment. Now, virtually all of you, I'm sure, will be familiar with guessment. This is the decision of Mr. Justice Leggett, as he then was before he rocketed to stardom and elevation to the Supreme Court. The decision is known because of the comments the learned judge made about the fallibility of human memory. He made a number of observations. For example, the fact that you have a particularly vivid recollection of a set of facts is a poor indicator that recollection is actually accurate. He made the observation that our recollection of beliefs are particularly fallible, and that all these problems are exacerbated in the context of adversarial litigation, where key witnesses have skin in the game. So the solution he proposed when making findings of fact about past events, disputed findings of fact, is to base those findings of fact on contemporaneous documentation and the inherent probabilities of the situation. And the obvious implication of that is that contemporaneous documentation is absolutely critical to the determination of cases that turn on disputes of fact. And it follows, therefore, that disclosure is a critical step in the litigation process. And it's a step, in my view, that people don't take appropriately seriously. They don't appreciate its full significance. So that's the overarching point. There are a number of subsidiary points. The first is that on the assumption that the key documentation is held by one party, and typically it'll be the respondent in a reason why discrimination or whistleblowing case, the reason why the impugned decision was taken will be within the knowledge of the respondent. The respondent will hold the key documentation. So until there is disclosure, the parties are not on an equal footing because one party has access to that key documentation and the other doesn't. A related point is that until you've seen the key disclosure, the documentation, the evidence on which disputed findings of fact will be determined, it's very difficult to give informed advice about prospects. And one of our functions as lawyers is to give expert informed advice. As a public value in our doing so, there's no point in hopeless claims clogging up the tribunal system. And none of us as lawyers should sit on the fence when asked to give an assessment of prospects. It's very difficult to do so if you haven't seen the key evidence on which critical disputes of fact will be based. So I might say, well, this looks a very plausible case, but I will know that there may be a smoking gun email which either supports my opponent's case or definitively undermines it. But until I've seen that, I can't give any clear advice about prospects. And that's a real problem. And that adds to cost because until you can give informed advice on prospects, the likelihood of settlement is significantly reduced. So these various factors, in my view, support early disclosure. The furtherance of the overriding objective means that the earlier in the process that there is disclosure of key documents, the better. I think going beyond that general point, parties, particularly those acting for claimants, ought to be far more proactive and imaginative in the sort of disclosure orders that they seek. Mark's already referred to the Sarnoff case. This is the case that established, to many people's surprise, that the governing rule from which the tribunal's powers to order disclosure is derived is Rule 29, not Rule 31. Now, a lot of the cases refer to the tribunal's powers being coterminous with those of the county court. The reference to the county court powers is Rule 31, there's no reference to county court powers in Rule 29, which is drafted in the broadest and unqualified terms. That being the case, I think it's entirely legitimate for you representing your client to invite the tribunal to depart from the standard order for disclosure, which is to make disclosure on a particular date, in the sort of ways I'm about to suggest. And I think inspiration can be found from Practice Direction 57 AD under the CPR. Now, this is the practice direction that governs disclosure in the business and property courts. It's only been implemented since October of last year, so it's relatively new. And you're probably thinking, well, of course, the business and property courts are different from the employment tribunal, which I do appreciate. But the significance of the practice direction is that it provides a carefully thought out disclosure regime that is designed in a proportionate and cost-effective way to do justice to those cases. And all those principles will be equally applicable, in my view, to the employment tribunal. So whereas typically, let's say a case started in March of this year and the first PH is tomorrow, so early May, and the parties have exchanged agendas, there's agreement that it's a 10-day case, the likelihood is it's going to be heard in a year's time, so in May 2024. Typically, the battleground on disclosure will go no further than should disclosure be in, say, November or December of this year. And there may be a bit of toing and froing and the tribunal will make the decision. And my suggestion is that you need to address the critical stage in disclosure far more proactively before that PH and invite the tribunal to make more sophisticated or nuanced orders. So returning to this practice direction, the first point is a distinction is drawn between initial and extended disclosure. And extended disclosure may or may not happen. So disclosure happens at different phases, and it seems to me there's no reason why that principle shouldn't be approached in the employment tribunal. If it's essential to further the overriding objective that key documents are seen as early as possible, shouldn't you be pushing for an order that documentation relating to the critical issue in the case be produced sooner than perhaps November or December? The balance of the documents can await that later stage. The likelihood of settlement is far greater if that were to happen. The practice direction introduces the concept of known adverse documents. So we all understand what an adverse document is. It's a document that undermines your own case or some contention that you've made or supports your opponent's case. Known adverse documents are documents other than privileged documents that a party is actually aware of without conducting any further search for documents that are or were previously within its control and that are adverse. So first point to note, disclosure under the CPR is stating whether or not a document exists or existed. It's not producing a document, that's inspection. And missing documents are often very important. And if you have suspicions that your opponent will already have deleted key WhatsApp messages or text messages or emails, you are entitled to press for information about those missing documents. That is what disclosure is. So known adverse documents are those that the party knows are adverse without conducting any search. So why shouldn't, in my hypothetical case, typically the claimant, but it could be the respondent, press for disclosure of known adverse documents within, say, 3 weeks of the PH? You can then have disclosure of the rest of the stuff in November or December, but it's very difficult to resist that, it seems to me, in circumstances where there's no requirement to carry out extensive searches, because the whole concept of known adverse documents is that those are documents that you already are aware of. And I don't think it's an application that people normally make at these sorts of PHs. I'm suggesting that before the PH, because disclosure is so important, it's sensible to address the issue in pre-action correspondence, write to your opponent saying these are the disclosure orders we will be seeking. There may be a disclosure order for known adverse documents. It may be disclosure order, early disclosure on documents relating to the critical issue in the case. It may be you have suspicions that there will be critical WhatsApp messages around about a key decision, and you want to see those at an early stage and see whether or not that can be agreed. If it can't be agreed at the PH, rather than simply saying it should be October rather than November, the date for disclosure, say this is the specific orders that we are seeking. Final point on this, my first point, consider, particularly if you're acting as respondent, producing at an early stage those documents that help prove your case. So I'll give an illustration. I did a case last year. I was acting for a hedge fund. The claimant, who was the chief compliance officer, a lawyer, brought a claim for whistleblowing after she'd been booted out. And the respondent's case was that she was kicked out because she was bad at her job and fell out with everyone. Her case was, I fell out with everyone because I kept on making protected disclosures. So that was a fairly familiar battleground. It was pretty clear she had made protected disclosures. That was the nature of her job. And we disclosed on a without prejudice savers to cost basis a privileged communication from my client to my solicitor in which advice was explicitly sought. How can we get rid of X? She's crap at her job and she falls out with everyone. And it was very compelling evidence of what actually was the motivation for the dismissal. It wasn't she keeps on raising concerns about breaches of legal obligations or anything of that sort. That was produced on a without prejudice basis in an attempt to undermine the claimant's confidence on the critical reason why question and in an attempt to facilitate early settlement. My second point, far shorter, is the importance of the solicitor taking charge of the disclosure process. And the key dictum is paragraph 200, final paragraph of a decision, Square, Global and Leonard. It's in the IRLRs. It's a High Court employee competition case. And the judge endorsed guidance from the well-known textbook Malik on disclosure, which I've quoted on the slide. And the key point is that to fulfill his own duty, the solicitor ought to take charge of the key documents as early as possible. And critically, the client should not be allowed to decide relevance. Now, in my experience, particularly in employment tribunal disputes, that guidance isn't always followed. In other words, often it will be the solicitor giving advice to the client about what sort of documents they should search for, but the search themselves is left to the client. And I think particularly if you're acting for a claimant, you need to be aware of this principle. When you write at the beginning of the dispute, reminding your opponent of the obligation to preserve documentation. Also, I think, ask them to confirm that they will comply with this obligation. And it may be that you need to be more precise than that and to home in on the areas with which you're particularly concerned. So it may be that you're not bothered about who actually goes through the personnel file to pick out the relevant documents, but that the key decision maker who you understand on instructions, and it's a point that Mark made, you do need to get from your client instructions about where the key documents might exist or be. If the key decision maker is known to have been a prolific WhatsApper with key people, would he or she have sent WhatsApps about the critical decision before they sought advice, ill-advised WhatsApp? These are the key documents. If you're concerned that that person may delete those documents, now it's turned litigious and they realise how damaging or potentially damaging they are. You do want to press this for the solicitor to ensure that they take charge of the iPhone or whatever it is, take an image of the thing, and that they carry out the relevant searches, and that you seek express confirmation that no relevant documents have been deleted. Because as I say, that's part of the concept of disclosure. And I did a case last year where I was acting for an NHS trust. It was a multi-week case. We won the case comprehensively, but during the course of the case, a big problem arose on disclosure, and it turned out that my solicitors hadn't advised the trust to preserve documents. A category of documents had been deleted under a document deletion policy, perfectly innocently, but it was very damaging. And it also turned out that the exercise of disclosure had in effect been left to the trust, people with complete integrity, but it allowed the claimant to attack the process of disclosure more generally. And it was a big problem in that arose during the course of the case. And of course, the claimant perfectly naturally tried to make of it as much as they could. So I think as a solicitors, you need to think proactively at the beginning, to what extent am I going to take charge of these documents so that if these issues arise, you've got a defensible position. Those are my 2 points. Thank you very much.